Hi, everyone. I'm Kelly Ainsworth. I am joined by Jon Orent from Motley Rice, one of the premier firms leading the charge in the GLP-1 litigation. Motley Rice has a long history of representing clients harmed by dangerous drugs and medical devices. Jon's work on this litigation has positioned him as a key figure in the ongoing efforts to hold manufacturers accountable. So our goal today is to break down what's happening in the GLP-1 litigation, why these cases matter, and what other law firms should know as this tort continues to evolve.
Well, I want to first thank you so much for having me on today and giving me the opportunity to tell the story of this litigation and all of the people who have been harmed by these powerful drugs.
So, Jon, for anyone who isn't fully up to speed yet, can you give us a quick rundown of what the GLP-1 litigation medications are and how we got to the point where drugs like Ozempic and Mounjaro are now the subject of a major national litigation?
The GLP-1 litigation, GLP-1 RAs are the type of drugs that are commonly referred to as Ozempic, Wegovy, Mounjaro, Zepbound. And anyone who has watched TV over the last few years has seen the explosion of commercials related to Ozempic. I mean, I think we all knew the jingle for Ozempic. We've seen the marketing for Mounjaro. And what's really happened is that over the last half decade or so, these two manufacturers, Eli Lilly and Novo Nordisk, have poured hundreds and hundreds of millions of dollars into advertising these drugs, which were originally intended to treat type 2 diabetes and have become sort of this miracle drug for weight loss. And it's popped into the American culture, the American lexicon. What isn't talked about is the harms that can come from these drugs, including gastroparesis, including something called an ileus, which is a bowel obstruction. We've seen all sorts of other harms, gallbladder harms, blindness, you name it. There are some really powerful harms from these drugs. And really, it comes from the overpromotion, oversale of these drugs, and that we think with appropriate warnings, there is a place for these drugs in medicine, but they shouldn't be sold to everybody who wants them as they are right now.
Right. So early discovery suggests that these companies, Novo Nordisk and Eli Lilly, you mentioned, knew more about the gastrointestinal risks than they disclosed. Why
And
is there a focus on these two manufacturers specifically? And do you see other manufacturers or compound pharmacies getting added in the future?
so we don't. Right now, only the name brand manufacturers, Novo Nordisk and Eli Lilly, are named in these cases. And that's because these drugs are still on patent in the United States. There are compounding pharmacies that do sell these drugs, but that's not the focus of this litigation. The focus of the litigation is on the name brand drugs. And there's a whole lot of legal reasons why we think cases against compounding pharmacies may be more problematic. But I think at its core, one of the things that we really think is that, again, talking about the labels of these drugs and the warnings of these drugs and how the companies, we believe, had a lot of information early. In fact, if you go and look at the latest labels in the United States, there was a label that came out in October of this calendar year, 2025. It added a whole bunch of things that we've been saying all along should have been added to this label. And if you were to take a combination of the European label, which has things like delayed gastric emptying as an adverse event on it, something that is a big part of our case, and add it to the whole list of things that have been added to the American labels, you get closer and closer to an adequate label. So I think the companies have actually started to realize that there are real problems with their labeling and have made incremental changes, but not quickly enough, not with the information that was available at the time. And we certainly think that a lot of people their injuries could have been prevented had this information been available sooner and more thoroughly.
Specifically, how has the case evolved to include eye injuries? And are those being treated similarly or different in this case?
That's a great question. So the eye injury cases are just starting to be consolidated. There was a consolidation order that came out last month in New Jersey State Court. The New Jersey State Court created a second consolidation. So they created what's called an MCL in New Jersey. It's the functional equivalent of a state court MDL. They created one for the gastrointestinal cases, but they also created one for the eye injury cases. This month, the JPML heard arguments on the creation of a MDL specifically for these eye injuries. We have yet to see where those are going to go, whether they're going to be combined with the gastrointestinal injuries or how they're going to be managed. But what these cases are all about is a condition called NAION. And the typical presentation of NAION is that a patient wakes up in the morning blinded in one eye. It is painless, but typically comes on suddenly. And for the most part, we see it close to the start of the drug or close to dose escalation. What's unique about this condition is the amount of literature that has come out showing the causal association between it and these GLP-1 drugs over the last year. So the first study was published on July 3rd, 2024, and there have been probably a half dozen to a dozen big studies that have been published in that interim year and a half that all say the same thing, that bring us from association to causation. As we look at this case, we see yet again, we think that the evidence was there for the manufacturers. We think that they could have and should have warned of this long before they have. And in fact, in the United States, they still aren't warning about these conditions. In Europe, they are. It's very concerning to me that the message that's being sent by these companies that it is okay for Americans to not get the same warnings that Europeans are getting. We think that the American public clearly deserves the same level of warning as everyone else in the world.
Why
And
wouldn't we? I mean, that's
exactly.
scary. What you said, waking up with one eye blind. Is that typically temporary or permanent?
It's a permanent condition, and it is
God.
devastating to all of our clients. In fact, we have clients because of the lack of warning and the lack of clarity associated with this soon enough that have actually been told to stay on the drug and have lost the other eye.
Oh,
And for those people, I mean, for any of these people, this is not a complication. This is a life-altering catastrophe.
really
And
life altering.
it really is. And we see this time and time again of people who try and be diligent about their health. They ask the appropriate questions of their doctors, and just a simple warning would have done so much good for these people. And it's an honor to represent these folks because these are things that shouldn't happen to anybody.
Yeah, thank you for doing all this. We need people like you out there. Now, something I really wanted to talk about. These drugs have become a very big part of pop culture, as we are seeing everywhere, with celebrities, social media influencers, even medical spas promoting them. How does that environment complicate the legal, but also the ethical issues that you're seeing?
Well, it certainly complicates the jury's perception of things,
Right.
right? There is this pop culture phenomenon with Ozempic, and quite frankly, it's not an accident. This is the result of a concerted effort of spending hundreds upon hundreds upon hundreds of millions of dollars in advertising, in tens and tens of millions of dollars in direct payments to doctors. We've never seen a marketing program like this before for a pharmaceutical drug. And it has really shaped the way that the public views these drugs. The public perception right now is that these are magic drugs. They solve all problems, when in fact, they're like any other drug. There's a valuable use for them, but that valuable use can be outshined by this over promotion effort so that more people are taking the drug without the precautions necessary to take it safely. We think that the rest of the story needs to be told. Whenever you see a celebrity endorsing one of these drugs, we need to hear about a balance. And the FDA regulations are very clear on the need to balance the risks and the benefits in any communication that is sponsored by a company. I think the FDA has really started to waken up recently to these sort of things and has actually issued warning letters to Novo Nordisk and to Eli Lilly around the use of certain celebrities and in particular some broadcasts going back a few years. So the important thing is that whenever you talk about a pharmaceutical drug, you've got to balance those risks with any benefits that you talk about. And that doesn't mean saying them with a wink and a nudge and just sort of running through them. It means giving them the equal import of the benefits that you're selling.
Right. It's about caring about your patients and your clients. Why would a company not want to warn them? It's protecting themselves too. You'd think they would do the right thing, but clearly not. So this litigation consolidates multiple GLP-1 drugs under one litigation. Can you explain how the court is organizing these claims and which injuries are being prioritized?
So right now, the GLP-1 MDL judge has done something called bifurcation, which means she split the case into half. and wants us to proceed on these big, what are called cross-cutting issues, so the issues that affect all plaintiffs in the case. We're working towards going through issues of failure to warn, whether or not, as a matter of law, the warning is adequate, and with that, whether or not there's any preemptive effect of federal law. So we're the manufacturers free to put the warnings on that we say that they should have had. Preemption is the defendant's burden to prove. It's not the plaintiff's burden. And as I said earlier, we've got to show in the first instance that the warnings were not adequate as a matter of law. We think that the addition of new labels and the ever-changing nature of these warnings to slowly start to add the things that we've been saying all along almost demonstrate for us the lack of adequacy of the warnings that were on the products when our client took them. The other issue that we're dealing with on the front end is what's called general causation, or the ability of the drugs to cause the harms that we're alleging. And so for the biggest groups of harms, gallbladder, bowel obstruction and ileus, delayed gastric emptying, gastroparesis, and gallbladder, we have to prove general causation. And so we're going to be putting forward general causation reports showing that these drugs are capable of producing these results. In fact, we are going to be producing our expert reports on this in about the next week. The defendants then have, I think, about a month or two to provide their own expert reports. And then we're going to start briefing these issues. And the hope is that we will have orders by probably the fall of next year that allow us to move into a bellwether process. That's the hope right now. And we feel very good about the state of the science, very good about the state of the documents, and all that we've done over the last 18 months to uncover from within the corporate files. So we like where we're positioned going into this, and are looking forward to putting out there onto the public record what we found.
Wow, you seem very well prepared for this. That's comforting. So just to recap real quick, the two sections of the lawsuit are failure to warn and proving causation, correct?
Exactly. So once that occurs, we hope we'll be in a position to start selecting bellwether cases, so test cases, to actually start bringing people some justice and putting these cases before judge and jury.
Great. So I know you talked a little bit about state court in New Jersey, but what else is happening in state courts regarding these claims?
So there's a few things happening in a handful of state courts around the country. There's probably less than 10 cases filed in Delaware state court right now. The Delaware cases have been consolidated before a single judge, and that judge is actually coordinating with the federal MDL court to some degree. We really are in the early phases there. What I will say is those plaintiffs are in Delaware state court primarily because Novo Nordisk's American entity is based out of Delaware, so there's no diversity of citizenship to bring it to federal court. There's also a consolidated case for both eye injuries and gastro injuries in Indiana, where Eli Lilly is based. And that has just started to meet as well. So this is the state court process is really just starting to catch up to where the MDL is, and we're not sure exactly what that's going to look like right now. And then the final major state court setting is New Jersey, where Novo Nordisk's principal place of business is based in the United States. There are about 1,000 cases in New Jersey right now, and that includes both eye injuries and gastrointestinal injuries. They're technically divided into two different MCLs, or again, those state court equivalents to an MDL. And we expect probably in the first third of next year to have an initial status conference and really get to work there. So stay tuned on the state court front. Really, things are just starting to develop, and we hope that by the time really the state courts get going, we'll already be or will be close to a bellwether process in federal court.
Crossing my fingers. This next point I know you touched on a bit, but maybe you can expand. Manufacturers are clearly relying on labeling defenses and physician discretion arguments. How are plaintiffs refocusing the conversation to show corporate accountability instead?
Physician choice is a very important thing, and we're not saying that physicians don't have a responsibility to know everything that they can about a drug. But the reality is physicians get their information primarily from one place. That one place is the label of the drug. And so if a company doesn't provide a physician with the labeling information that doctor needs, that doctor can't make a decision along with the patient whether or not the information supports the choice to take a drug or not take a drug. And so the whole case is really about giving doctors the freedom to actually make a meaningful choice and making sure that the labels have everything that a doctor needs to make that choice with the patient. And so this case really supports that notion of doctor choice. And we're not trying to take this drug away from anybody. But what we're saying is, listen, if you're going to take a drug, it shouldn't be sold as a miracle drug that has no risks whatsoever.
Right.
A patient deserves the full story. To date, they haven't been able to get that full story. And so we have these plaintiffs who are seriously hurt, who were never given a meaningful choice to make. They thought that there was a minimal risk when in fact there was a much larger risk than they had any idea of. And that comes back to what this case is really about. And we think that that message will resonate with jurors.
For sure. What you were saying about doctors relying on their labels, it makes me think, for example, if they were to read something in a textbook, they're not going to go double check that the textbook is accurate. That's their source. That's where they're getting their information. I totally agree.
Exactly. And if you think about where doctors, the rest of the information that doctors get, they get it from journals to some degree, but they also go to conferences. And what do we see? We see these conferences very often now are being sponsored by the companies that put forward certain drugs.
Mhm.
That certainly colors the view of things. So it's really important, again, this notion that any materials that are produced by a company get a full balance between risks and benefits. And we think that that's been missing not just from the labels, but from the marketing materials that show up at conferences, from the leave behinds that get provided to doctors. At all steps along the way, doctors and patients alike need to get the full information, the balanced information. And right now, they're not getting that. And that deprives everybody of a meaningful choice.
That's a really good point. Motley Rice, your firm specifically, you guys have led some of the nation's largest drug litigations. How are you ensuring that these clients receive both high quality representation and compassionate communication?
One of the most important things that I tell all of the folks that work on my team is that we need to treat every client as though they're our only client. That's their expectation. And when we choose to take on a client, that client doesn't care that we might have 100 or 1,000 other clients. They care about their own case, and they deserve to care about their case, and they deserve to have that expectation of us. And so we need to provide appropriate care for each client, and that means returning any call, properly getting back to clients, emailing or sending updates on a regular basis. And it also means, quite frankly, vetting our cases really well, because it is extremely unfair to a human being to drag somebody through years of litigation where no matter what you say about expectations, their hopes are up that they're going to get justice from this if you can't do something for that person or you can't do something meaningful for that person. And so setting expectations early, being honest with your clients about what the reality is of a case, and being very selectful on the cases that you actually do take so that you can represent those people well. You can actually advocate for them.
Right. And that's why at TSEG, we thoroughly vet these cases so that when we're sending them off to the law firm, they're getting only the most qualified cases. We'll take their specific criteria and make sure that gets across. So I understand how important it is, especially with the severity of these injuries.
Absolutely. And I tell this to my clients, and very often I give clients, anytime I talk to one, I usually give them my cell phone number directly. And, very few clients take me up on that offer, but the reality is it is a responsibility for each and every one of us to pay attention to our clients and treat them as though they're individuals, not part of a mass machine. And it's an honor to represent each one of them. And we have to treat it as a sacred bond between lawyer and client. And really, we cannot lose sight of that. If you ever hear me speak at any other conferences, this is sort of my soapbox issue, because I really believe that part of the duty of each of us is to make sure that we are adequately representing each and every person that hires us and giving them the individual attention that they deserve.
And that's super respectable. Thanks, Jon. Just to close it out, for firms considering participating in the GLP-1 litigation, What do you see as the biggest opportunity to make an impact, both on their clients and the broader fight for corporate accountability?
One of the things is sort of goes back to what we were just saying is vet your cases. Extremely important, not just for clients in this case, but in all litigations, that we put a best foot forward, making sure that our clients are truly injured and have the supporting documentation necessary to be able to successfully bring that case. So I would tell people not only to vet your cases, but get them on file quickly. This is an ever-changing litigation right now. We think that there are many people out there who have inventories of cases that haven't yet filed their cases. And we'd say, now's the time to file those cases, because at the end of the day, this litigation, ultimately, people need to know how many cases are out there. We need to know what the quality of those cases are and what they look like. And so I would say to people, get your cases on file soon. We have a short form complaint now, and so vet them and get them filed soon. I think those are the two biggest things that people can do right now, so that we can look at these cases as part of a bellwether process. And when we start thinking about where this litigation is going, we have an idea as to how big it actually is. And that's one of the problems in any litigation, is really understanding what the size and magnitude of something is as quickly as possible is an important item.
Totally. You've done a really great job of furthering everyone's knowledge on this, and I really appreciate you taking the time to talk to me about this. It's been very informational.
Well, thank you. Again, I really appreciate the opportunity, and we really believe in these cases. And if anyone has any questions, certainly feel free to reach out to me directly. I'm always happy to talk about it. So thank you to the folks at TSEG.
Yeah, thank you so much, Jon.